Artificial Intelligence Law and Justice, Session 18. This is first class of the two classes on AI and patents. In the last 4 sessions, we had a very good overview of the issues in copyright and copyright and AI, where we touched upon many emerging issues, including the ones which raise fundamental issues in copyright versus AI. And more importantly, we also noticed that the idea of authorship versus the idea of AI as an author has got a lot of controversial implications, particularly when AIs are becoming all the more creative and then all the more challenging in terms of their capacity. So in the 4 sessions, we touched upon them, and we also dwelt upon some of the policy measures that are being proposed, if not fully taken, to address some of them. In these 2 sessions relating to patenting and AI, will be in one sense a parallel discussion of the debates and issues in copyright, in the sense that there are some fundamental issues that are very common here: criteria, authorship if it is copyright, inventor in patenting. And there are also some fundamental assumptions in both copyright and patenting, in terms of that both are incentives to innovate and then incentives for creators as well as innovators to enjoy the economic benefit out of their innovation. But there are a lot of differences because patents and copyrights by nature are very different forms of protection for different types of outputs. So that also we will see and discuss and then in detail in the both classes. And then we also need to keep in mind that AI is not only questioning the fundamental issues in IP law, it is also moving in a direction that we may have to either create new rights vis-a-vis the AI created works within courts, or we may have to substantially bring changes in the way we look at inventorship, authorship, human mission collaboration, human as the inventor, human as the writer or author. How we will address them is a tough task, but we can at least try to understand them in the 2 sessions. So purpose of the patent law is to investment in R&D, monopoly rights patentees, 20-year patentee, and then this is all we know. And then abstract ideas like pure algorithms cannot be patented, unless they are embedded in some. There are various different ways countries define what is patentable, what is excludable, what is exactly can be patented, what criteria. And then the patenting criteria are novelty, inventive step, industrial application. These are common everywhere. And then only technical features contributing to solving the technical problem are considered as inventiveness. If AI does not result in it, it could be said inventiveness is missing or it doesn't fulfill that criteria. Similarly, abstract algorithms are also excluded in this idea in the sense that they cannot be patented. But in future, these things may undergo change. Then comes disclosure requirements, like patent is a bargain where you disclose and then in grant you are granted monopoly subject you fulfill other criteria. But as we know, AI systems are more or less black boxes. They lack transparency. They won't be able to explain. For example, the developer won't be explain as to what exactly the AI system did to come to this conclusion. And some of the AI-related inventions may not meet the full disclosure norms for the simple reason people can explain how it works. But that level of explanation cannot be taken as 100% disclosure, or is not the disclosure that would meet the criteria set in the patent law and practice. So there are ways to address them in future which may arise, or people may say that a disclosure of an AI-related invention may be little relaxed in the sense that you are able to sufficiently prove that this disclosure is an acceptable disclosure, and then this disclosure can be testified and tested and proven. The second thing is whether this disclosure is correct or we can be verified and tested, but not sufficient means what else is needed can be identified, and then the developer can be asked to give that information or give some supplement information on the working of the machine, the algorithms or the way why it was arrived at. So what level of disclosure, what documents or what evidence we would need is something is to be debated upon. So alternative protection mechanism is a trade secret, but trade secrets again are problematic because by chance they may get disclosed or somebody may reverse engineer them. And then when it comes to AI related trade secrets, it is also possible that trade secret as a protective mechanism, extending that to AI will work to some extent because AI is a very complex one. A trade secret for a chemical formula, a trade secret for a one formula, or trade secret for something special and which only one person knows is good. But a trade secret for a larger AI system is also feasible technically, but then later in future public policy may not give that because transparency in AI system might be needed or might be demanded on account of various factors. Then patent application trends, AI patenting continues to zoom, and then right from 2013 now half of them have been published, but as we will see in the next graph, between 2010 and 2023 has gone steadily significantly from 3,833 to 1,22,511, which means that patenting in AI is massive. But how many of the patents that have been applied for and how many of them have granted, what is their quality and all is something which we will not go into detail here. And as AI patents have been increasing like anything, last year itself it was about 30%. And then China leads total AI patents, accounting for 69.7 of all the grants. So this is what the Stanford AI Index to report, which is a very reliable one, says. But the numbers game here will be very misleading because the way patents are granted, their condition for being granted, the level of examination, and then the level of stringent norms being met varies from country to country. So just because China leads with total number of AI patents accounting for about 70% of all grants does not mean that AI innovation or patent related AI or AI innovation if measured through patents is happening in China. China is there with USA on many grounds almost running neck to neck. But if we use patent as the criteria to measure that, it will be totally misleading because the criteria for grant of patents vary from country to country. So this graph gives us an idea as to from where it started, from where it has gone. So the global trend is it is upwards, but then both China and USA are the primary movers here. What exactly is an inventive mission? Inventive mission is one thing that can come up with a specified product or that can come up with a specified formula or a typical innovation in the patent lingo. But then many missions, AI missions are not inventive missions in the sense that AI systems are creative, generative AI systems are creative to write a book, write a novel, create a 1,000-page encyclopedic novel. But then they are not the ones who can create a chemical formula or come up with a new formula for a new drug. I am not saying that it is not possible. All I am saying is that relatively speaking, the number of AI systems that are capable of this is relatively less. Dr. Stephen Thaler, the name of Dr. Stephen Thaler is now synonymous with DABUS, and then it is a very important case in patenting and AI, and there are a lot of discussion on his work in the sense that what he did, whether the creative mission with the creative mission which he used, how to link that with AI and patenting is something which is very important to understand. So based upon neural network simulating human creativity, he developed this creativity mission called DABUS. Using DABUS, he created within quotes inventions for patentability. So first created in 2018 2 patents he applied for, and then he listed DABUS as the inventor. And then he obtained rights as a successor in title, but not as the patenter. But patent applications offer a test for AI inventorship, so he went and then applied for a test, but then it didn't work out because the AI legal perspectives or principles are very different. AI systems cannot have ownership rights. They are not human, they don't have legal personality, they are not even legal personalities like companies or joint firms or limited liability partnerships. And then they cannot be considered as employees. Employee can be a co-patent owner, employee can apply for a patent and then assign the patent, employee can under a contract do for work for a company and then make claim co-patent inventorship if the company's norms accept it. But AI systems are the inventors under the current law and then confirmed by at least half a dozen cases in different countries. No, they cannot be classified as inventors, or at least when it comes to patenting, they cannot be listed as patented as an inventor and then granted patent rights. Further, inventors have the right to be mentioned as such. Like if I am an inventor, if I go to the court and prove it, or I have recorded evidence that I am the inventor with all the background document and then lot of work to prove that, I can claim that I should be mentioned as the inventor. Extending inventorship to make this right meaningless, because the first and foremost we are not even considering them as inventors. So when they are not inventors, we cannot extend that right to them. So out and out problem is the patent law is human centric. Only humans can claim patent, must be the ones who can be listed as and then granted patent rights. And here the human patent is very narrowly defined, or it is taken as physical personhood. Why we say physical personhood? Because cyborgs, half human, not exactly half human, but a human in whose body lot of computer chips, lot of digital devices are embedded, or a person who in whose brain and the nervous system there are controllable digitized devices and are there. They are also labeled in the popular thing called as cyborgs. But the patent law does not recognize that as personhood, not even the normal law. So technically, although we do not have the concept of cyborg acceptable in the legal term when it comes to patenting, but then cyborg is a concept which is there very much vogue in popular culture, in science fiction, in films, and then even in theoretical literature on many of the topics, including AI. So the human requirements in patent law are so drastic that only the humans in physical form, fully human, can become inventors. So the ownership again is a problematic one. AI systems cannot be authors or inventors, so everything flows from there. So AI systems cannot become this, become that, and then as we saw in the copyright, the same thing applies here also. So the black box nature of AI becomes a stumbling block here. Then the role of AI creators, allocation of rights, same problems would come. But you can increase the autonomy of AI algorithms, but that again won't fully solve the problem, because again it's very difficult to prove that those who design the algorithms or who enhance the autonomy could predict and then could also claim that everything was already foreseen. But questionable things come, a lot of issues come, even IP infringement becomes part of AI development. We have seen some debate, some controversy, some basic issues when we discussed about using copyrighted data for AI development. The discussion here or the issues here are very much parallel. In fact, they are not identical but very similar. So, text and mining, data mining exceptions are applicable. Patent output, potential output for right holders is applicable. Publicly available detailed summary about training data is being made, and then the same problems as in copyright, same thing also applicable here. So the problem is authorization to exception to patent law are similar to copyright but are very stringent, because normally patent law does not use within any country, any circumstances, the fair use doctrine except in a very limited sense. And then that limited sense again can be contested and has to be proven in a court. Or the fair use within courts limit, and then the right under patent law is almost next to nothing or very, very limited. So the copyright exemption may be, or fair use may be very broad, but we cannot shuffle that to Patent Act. So patenting as an innovative idea and concept and practice has evolved over the past few centuries, with lot of issues being debated again and again, with lot of questions being again and again, but some of the fundamental ideas have also evolved. In the patenting literature or the patenting law, a person skilled in art or PSA is someone who is recognized as the golden standard. So the inventiveness standard relies on what a person skilled in the art knows is known as prior art, or what the person in the standard skilled in the art can foresee or not only foresee but also can predict or can understand or can extend, is also question of in the Patent Act, in the sense that an invention which a person skilled in the act or can foresee or can say this is just an extension of that, whether that is patentable or not will be a disputable one. But then the PSA standard will have to evolve with the innovative missions, intervening missions, particularly when it comes to AI. And then this will raise the bar for innovative step as well as for patentability. So if this is not done in proper way, it will question and strike the very fundamental foundation of patent system, because we know about the person skilled in the art as far as humans are concerned. But we do not know about the AI systems, what are the level of skilled in the art we are talking of, we are not sure. And then the inventive machines can be very creative, very inventive. But will they be equivalent to considered as PSA? We are not sure. Coming to certain fundamental issues, AI in IP practice, irrespective of all the debates in copyright and patenting, has expanded. Because for the simple reason, AI has fantastic, phenomenal capacity to analyze, pattern match, and then sort out, give things in the way we want. And then more importantly, AI can also read thousands and thousands of patent documents and then also say this is the prior art from these patent documents. It's possible. It's also possible that AI can identify, if I put it some 100 or 200 patent documents, it can identify the whole patent document, everything after reading everything. It can identify and then give me some graph or some trees if I wanted to develop what exactly are the inventions, what are the inventive steps, what are the major patents or what are the key patents, or which patents have been repeatedly cited in all the patents. Those sort of analysis AI Act can do fabulously, fantastically. So, organizations like WIPO are using AI for categorizing patents and trademarks, and then for prior art search and machine translations, and then for formality checks. This is very legitimate. We would be surprised only if WIPO doesn't do it. But coming down to the national level patent offices and then registers of copyright and others, they are also extensively using patent related IP systems and then IP tools, because they aid in the right classification for the inventions as to mean which category, which discipline or which thing they would come, whether it would come under nanotechnology or whether it would come under chemistry or whether it would come under physical sciences. Those things they will be able to identify and say. And then patent screening and then drafting also AI could be used. More importantly, I can use AI to identify the trademarks which have been registered earlier, so that if I file a trademark, I should not get after the examination that if a trademark is very similar to or identical to or seems to be derived from this, so it can't be given. So AI can help in lot of pre-filing, pre-patent application filing, pre-copyright right claiming, or more importantly in IP practice, AI can help everyone. The patenter, the one who applies for patent, the IP attorney, the patent office, and also the people who contest and challenge the patents already granted. So the traditional scope of IP law is focused on human creation. Technological evolution of AI is now challenging it. And then authorship is the big question. Again, arguments versus argument, both sides there are a lot of arguments. But the creative, non-creative, human, non-human, all these debates, all these contentions are important. In the process of understanding them and debating them, we should not hastily alter the patent law foundations or IP law foundations. Because right now, what we know is not sufficient enough to come up with drastic changes, either in terms of standards or in terms of criteria or in terms of the fundamental parameters in both Copyright and Patent Act. And more importantly, today we won't be able to even predict what sort of technological developments would come. And then if the technology developments, since we won't be able to predict, we cannot develop a system that is 100% future proof. That is not possible. We cannot be able to fully anticipate, but we can still try to work out certain things, more like, test, see whether it works, and then go one step further. Rather, incremental changes or marginal changes might be a desirable option. Till we know enough about AI's creativity, AI's inventor right inventorship, and then we cross-check and then check and arrive at a fundamental consensus on some fundamental issues. If not, all the countries agree on each and everything, there are some exemptions which countries can give. Those exemptions are different, but the fundamental criteria, there should be clarity on it. So the better approach or the better advice here would be, lest before you leap, lest later you weep. Otherwise, if we relax the norms, patent inventions, patent applications will zoom. Because AI with creative capacity, inventive capacity will create thousands and thousands of patent applications with this, with that. But then this system will be finding it very difficult even to cope up with such a volume. Imagine 10,000 patent applications being filed by a single company with a team of 10 persons using a AI-based system focused solely on writing the AI patent applications and then claiming inventions. Then what would happen? Because AI can derive the prior art, AI can also try to cook up something as the novelty, AI can also be trained to cook up something as the inventive step, and then I dump it on the patent office. Patent system will collapse if AI system is used even to accept certain things. So the AI's impact, AI if outperform human intelligence, where will it lead to? And then AI leads a narrow task, but not in the broad, significant inventive shops. Then comes up AI, the whole slow AI-driven transformation, and then fundamental questions in IP. So, can a machine-generated invention be patented? Should a machine-generated be patented? This again is a question which Dr. Taylor again and again tried to come to grips with. Unfortunately, he was not very successful. On the other hand, generative AI's impact is also equally important, which we have already seen in the areas of copyright, which is also equally true to a great extent in patent. So the four responses to AI when it comes to patent law or can be summarized like this. This again is a somewhat sort of a simplification because picture is little more complex than that. Fundamental idea is patent system exists as an incentive innovation mechanism to promote innovation or to promote invention so that people can invent and innovate, society can benefit. So if the societal benefit or societal being benefiting from innovation is the idea, we need to identify the inventor who should be given incentive. So there are four broad views. Right now, no unique patent law response is required. We can continue to run the show as it is, trying that to human inventors. Some idea says let us be pragmatic. Let us not be too rigid or too human-centric or closing the eyes. No patent based on AIs, no patenting for inventions based on AI system. Let us close the eyes and then think what would happen if we keep on thinking like that. System may face more problems in the future than it is facing now. So take a pragmatic response, come up with some modest changes to the existing patent law, but then don't drastically change. And then there are also certain arguments like AI neutrality and AI generated inventions. Like AI is a technology. Patent law is technology neutral. Whether your patent relates to neurotechnology or nanotechnology or even mechanical engineering or electrical engineering or any discipline in science and engineering, as long as the criteria are met, you are not talking about this discipline is not under the one patents can be granted. We don't talk like that. So taking the technology neutrality in patent, particularly when it comes to interdisciplinary innovations where you need insights or work from different disciplines, knowledge from different disciplines. Let us look at that as the neutrality key point and then say that we will extend the same to AI and as a consequence generate patent in AI generated invention should be granted. This is the view. But the arguments not to change patent law are also equally strong because one, patent law is designed to technology industry neutral. So historically accommodated technology like software, biotechnology, genetics have come. So we need not now think that AI will be a major challenge to change it right now. AI has to fit within the patent law, which is possible. AI change may cost of innovating role of human inventors. So the central inquiry of the patent law is not technology oriented. Central inquiry or central concern of patent law is not whether this technology or that technology. It is meeting the human invention that should be incentivized. So if there is the need, if that is the fundamental idea of begin patent law, don't jump and then say we are going to change the patent law because a new technology, dazzling technology has come with so many things. Let us not rush. This is one view. The other view, which again says that human-centered nature of the invention, importance of human creativity is very, very obvious. On the other hand, Professor Donald Jarvis is a well-known IP expert, one of the perhaps the top-ranking IP experts in the world with rich experience and then has written lots and lots of books, also has authored many, many important articles. on patents, particularly on IP, and then different branches in IP is written. So he says, goal of patent law is to foster human development. So patent law should support and encourage human invention. And then IP rights in IP AI should be guided with human progress. And then the idea here is not to make some AI based companies or the Silicon Valley giants all the more and more billionaires, more and more powerful and rich. So if we can think in terms of human-centered progress, then human-centered IP system supports progress of science and useful arts. So based on those criteria, we can rethink the whole debate. That is what one of the ideas proposed by the people, including Professor Ravi, who talk about the human-centered nature of invention, not the human as inventor. Some pragmatic solutions are disruptive impact is going to come, and then it is around human inventors. Let us look at a pragmatic solution. Ensure the current functioning of the current patent system. Address inventions without a human inventor. Take it first. Then, this is a valid proposal, and the last bucket of proposal, different approach to manage the disruption, says that inventions without a human inventor should be given a consideration as to whether they fulfill the other criteria. Then, AI-generated inventions should be patentable. Approaches modest change to drastic shift. Machines or inverters for patentable publish is very drastical. Rest statical adjustment to shared claim. Okay, machine can be a co-inventor with 30%, 40% depending upon the machine's contribution. And then you broaden the view of the idea of the innovative process. Inventorship addressed attributed to people to using AI tools, but the AI tools cannot be given the inventorship. AI can be there as a co-inventor, or can be number 2 but not number 1, or can be number 3 but not number 1 and 2. Or the work for hire doctrine in patent law is very old and it's very valid, and it has stood the test of time. So AI can be listed as a co-inventor or as a work for hire. In a work for hire, I commission a person or I ask a person who works for me and to do something. So under the work for hire doctrine of patent law also, it is possible to accommodate AI. So that is one of the less radical approaches. But how to translate these things to practice, particularly when the whole AI versus the patent system is centered on one approach, human-centric approach. Regulatory responses has been also look into competition law principles, and then we will look at competition law and AI in a different context. So we need to look at AI disruption is not something that needs patent law changes, because all said and done, AI is not something that revolves around patent law. It revolves around a broader macroeconomic structure where venture capital, where the big 5-6 firms or the national governments or the other inventors or the universities and everyone is being a stakeholder. So the industry concentration control is one point. Broadening the AI economy, AI innovations through incentivization, national strategies is another point. And then creating an innovation-friendly AI ecosystem, which will also be an IP-friendly, is a third point. So there are a lot of objectives are there when we talk of AI system. So the regulatory response to AI and then the regulatory response in terms of IP in AI may be the same or may not be the same, because the IP response to AI may also look into competition law, whereas the pro-innovation approach to regulation may not look at competition law as a key part of the strategy, or in fact may see that as a limiting factor for innovation to flourish. But we will have a session on competition law and AI. So the Artificial Inventors project is a project they wanted to test. Professor Abbott and then a series of pro bono patent lawyers, they started filing from 2019, promote discussion and guidance on AI generated. This is like, testing. This is like you float something and then test how it works, or you develop something and then see how it runs. This is like something like a prototype testing. So they filed a patent and then they listed Mission DABUS as the inventor, but it was rejected on the ground which we have been talking of again and again, inventorship. So in the next session we will discuss generative AI and patent and patenting, and that will be the final session on AI and patents.